Is the future of emulation looking bleak? That is because recently the Yuzu emulator got shut down by Nintendo, and now we have an article by XDA developers talking about they're worried about the future of emulation. So let's take a look at this article by Adam Conway. This was done yesterday. So the main points of this article are the following: emulation's legal status is uncertain, with Nintendo taking actions against Yuzu. Memories past emulator lawsuits hunt modern developers of Yuzu and Citra, and Nintendo's crackdown on emulation complicates preservation efforts for active console. Let's begin. Emulators have largely been regarded as more or less legal, although the acquisition of ROMs and files needed to operate them might not always be. It's generally been accepted that individuals can legally dump their own games and BIOS files for archival purposes, and emulators distributed are typically provided quote as is quote end quote, meaning they do not function unless the specific files are supplied by the user. Emulators also offer quality of life improvement, including upscaling, better performance, and mods. True, we've seen that already. However, Nintendo's recent legal actions against Tropical Haze LLC, the company behind the Nintendo Switch emulator Yuzu, cast doubt on the current legal standing of emulation. Developers have begun to abandon their projects, leading to the discontinuation of emulators for systems as old as the Game Boy, notably Exophase, the developer of the Jurassic DS emulator, has made the app free on Google Play Store and pledged its release its source code. Emulation has been in a worse state than it is, and it's hard to see how things can get better. Let's continue on. Emulators are technically in a legal gray area. We can thank Bleem and Connetrix for that much. So there's another emulator here. In 1999, the company behind Bleem, appropriately dubbed Bleem Company, had created and commercially sold an emulator that could play PlayStation games on a PC or a Sega Dreamcast. Sony accused Bleem of copyright violation over the use of PlayStation BIOS on a personal computer, alleging that it would damage sales of PlayStations. The judge ordered a protective order in favor of Bleem to quote unquote protect David from Goliath. Despite this, legal fees and patent fees apparently eventually forced Bleem out of business. So yes, there have been emulators before other than Yuzu, other than Dolphin. But Dolphin, Yuzu, RPCS3 have been the common emulators for consoles. I'm not sure what's the best Xbox one, but I know those are the top three. And you gotta see where emulation is going, especially when it comes to game preservation. Sony also attempted to take down Kinetic for its virtual game station emulator. This emulator, like Bleem, could play PlayStation games and was originally built for the Macintosh, though was also later ported to Microsoft Windows as a corporate competitor to Bleem. Sony filed a lawsuit against Kinetic, being granted a temporary injunction that prevented its sales of the emulator. However, the case was closed with a ruling in favor of Kinetic, and Sony then bought Virtual Game Station from Kinetics and immediately shut it down. With both of these emulators essentially setting a precedent for emulation being legal, it's since been conventionally understood that emulation is legal. So we have seen two already, Bleem and Kinetics go down for two for almost some similar reasons. Bleem was forced to shut down after fees, and we can see that Kinetics was shut down right after Sony bought them out. They just bought them out for Virtual Game Station. Now we get into the modern consoles. Things get murky with modern gaming consoles: PS5, PS4, Nintendo Switch, Nintendo GameCube, if you want to add that one, because they just mentioned Dolphin Emulator here. Preservation is hard to argue for an active console. There are a few elements of the Nintendo lawsuit against Yuzu that differ from those lawsuits of the old, and why many were curious how a judge would rule if it had gone to court. Emulation fans love to argue that emulation is important for game archival purposes. That's true, especially in the wake of online storefronts for the likes of Nintendo Wii and the Nintendo 3DS shutting down. It's hard to argue that emulation is for preservation purposes when a console like the Nintendo Switch is an actively supported console is the one being emulated. That's true too. Nintendo Switch is still being active, and yes, there are already rumors for the Nintendo Switch too. But because Nintendo Switch is still active, that's where it gets murky when it comes to emulation. It's not like the Nintendo GameCube where that thing has been retired for a long time. That's no longer active as much. But when you talk about a very active console, yeah, that's where it gets a little bit dicey. It's very dicey once you get to active consoles, especially PS5, PS Nintendo Switch, and I would I would call it active still PS4 and Xbox Series X and S if you do Xbox emulation. On top of that, Nintendo's issue raised in the lawsuit was not so much emulation itself, but rather the dumping of decryption keys from a console. Those keys, Nintendo alleges, are not possibly attained through legal means, but those keys are what enables the emulation of those games in the first place. Like with games, however, those keys can be distri- distributed online and shared through illegal means so that people without a console can still play those games through. You can still play those games without a console and using the download on the PC. So that's why a lot of people are hacking their own Nintendo Switches so that they can get the BIOS files and the ROM file, dump it, literal dump it on their computer to play with the user emulator. That's how these work. It's the same thing for It's almost the same for RPCS3. You have to you have to hack your own PS3 to get the BIOS files, BIOS, and get the ROM for the game that you want to play on your PC. Let's continue. With all that said, it's pretty clear that Nintendo feels that emulation of a Nintendo Switch is essentially impossible through legal means. While Nintendo's accusations don't really apply to other consoles, you can't necessarily blame emulator developers from not wanting to find out if they're doing will have Nintendo come down on there in the future. Here's Dolphin Emulator, our favorite emulator of all time on this channel. Interestingly, Dolphin Emulator, which has been actively developed for years, actually includes a copy of the Nintendo Wii's common key in its source code. The team behind Dolphin does not believe this is a problem following legal advice, said, stating in a blog post at the time, and quote, "We're disappointed to see many people on YouTube and social media didn't even consider that maybe the team had done their research and risk analysis before including the keys, and just assumed that now that there was, quote, pointed out to us, and quote, we would remove them. However, we do not think that including the we common keys actually matters. The law could easily be interpreted to say that circumventing a we disk encryption key also means it's a violation. As such, it is our interpretation that removing the weak keys would not change whether the exception in 17 USC section 21201F applies to us or not. With Yuzu Shutdown, this stance has not changed. Defiant in the case of Nintendo, the Dolphin Emulator team issued the following statement at the 10th of March, just days after Yuzu was taken down. And they said, "We have no plans to discontinue Dolphin at this time." That's true. I'm still using that. We reached out to Dolphin for further comment and did not receive a company's response at the time of the writing. So yes, um, if we take a look at 17 USC 1201 in terms of law, let's have a look at that really fast. It that is This is the law according to Legal Information Institute 17 US Code 1201 Circumvention of Copyright Protection Systems. And here is what the law says. I'm not gonna read the whole thing, but this is basically copyright, law enforcement, all that good stuff. Okay. So if you want to read this for yourself, I will also link this in the description if you guys want to check this out. But let's take a look at a little bit of the article. The article said section F, 1201F. Okay, so let's take a look at 1201F. 1201 1201F says the following: reverse engineering is the section that is in play here. And they also said, let me just see. So reverse engineering, number one, notwithstanding the provisions of subsection A1A, a person who has lawfully obtained the right to use a copy of a computer program may circumvent a technological measure that effectively controls access to a particular portion of the program for the sole purposes of identifying and analyzing those elements of the program that are necessary to achieve interoperability, interoperability of the independently created computer program with other programs and that have not previously been readily available to the person engaging in the circumvention. To the extent of any such acts of identification and analysis do not constitute infringement under this title. The number two, notwithstanding the provisions of subsections A2 and B, a person may develop and employ technological means to circumvent circumvent a technological measure to circumvent protection afforded by a technological measure in order to enable the identification and analysis under paragraph 1 or for the purpose of enabling interoperability of an independently created computer program with other programs if such means are necessary to achieve such operability to the extent of doing such does not constitute infringement under this title. And number three, the information acquired through the acts permitted under paragraph 1 and the means permitted under paragraph 2 may be available to others if the person referred to in paragraph 1 or 2, as the case may be, provides such information or means solely for the purpose of enabling interoperability and independently create a computer program with other programs and to the extent of doing so does not constitute infringement under this title or violate applicable law other than the section. And number four, for the purpose of this subsection, the term interoperability means the ability of the computer programs to exchange information and of such programs mutually to use information which has been exchanged. Okay, so this has something to do with more of enabling the identification and analysis under paragraph 1 and interoperability, as well as the elements of the program to necessarily achieve it. So if we take a look back at the article, it says the following. Let's reread the quote and let's apply that. We're disappointed with so many people on YouTube and social media didn't even consider that maybe the team had done research and risk analysis before including the keys. Keys being one of the things that they need to include here. Okay? And then assume that now that was pointed out to us, we will remove them. However, we do not think including the keys actually matters. This law could be interpreted as to say circumventing a we this encryption by any means is a violation. As such, it is our interpretation that removing the we keys would not change whether the exception in 17 USC 201 1201 F applies to us or not. So the fact that the we keys circumventing we key right here that was talked about in the code law. Circumvention is the play here. So as we saw here on the reverse engineering section, circumventing a technological measure that effectively controls to access a particular portion of a program for the source for the sole purpose of identification. That's where it's coming from, section F. Okay, that's according to Cornell Law School Legal Information Institute, or LII. LII. Let's continue on in the article. Um, Developers for the Dolphin Emulation project have also stated that asking users to dump their own Nintendo Wii common key or distributing it in the source code is the same legally. According to the legal advice they have received, given that Nintendo requested that Valve do not allow Nintendo Dolphin Emulator to come to Steam, but then made no further moves after all. After it seems to suggest that Nintendo is happy to leave to leave Dolphin Emulator alone, at least for the moment. If you guys remember, Steam actually had a release, or was about to release, the Dolphin Emulator on Steam. However, that was taken down. So you can no longer get that on Steam, but you still get the Dolphin Emulator through their website on Dolphin Emulator. So Nintendo said, you know what, we're happy. You can keep Dolphin up, at least for the moment, as we can see here. Because you never know. Now that they took down Yuzu, they could take down Dolphin if they wanted to at any time. But like we mentioned earlier, right here, Section 17 USC 1201 F, according to Cornell law. Looking to the future, we're almost done with the article. Trust. Following the statement, both Tropical Haze LLC and Nintendo of America have asked a judge to rule on the following: quote, developing or distributing software, including Yuzu, that is its ordinary course of functions only when cryptographic keys are integrated with authorization violates the Digital Millennium Act, Copyright Act prohibition on trafficking in devices. They circumvent effective technological measures because the software is primarily designed for the purpose of circumventing technological measures, as we discussed in Section F of 1201. To be clear, the statement does not set precedent, but we're asking a judge specifically to rule on a case, as this may still create legal boundaries that emulator developers don't want to touch. In the future, it could be used as an argument that Tropical Haze LLC asked for this ruling to be the case. It won't be necessarily be legal binding, but it's yet another push in the direction of preventing emulators from being legal. With more emulators beginning to shut down, such as pizza emulators, and drastic soon to pull the plug, Developers are clearly scared of repercussions from Nintendo. While Nintendo may not be legally right, and nobody can say if they are until a lawsuit actually goes to trial, whoever takes on the case should be prepared to go to the way of Carnetics and Blame even if they win, with the cost of fighting it be ridiculously high. Yeah, especially with Nintendo, you do not want to mess with Nintendo when it comes to lawsuits. They're they they own it. They make sure they shut down everything. Remember, Nintendo was going to investigate Power World for Pokemon, also under copyright. Believe it or not, because some of the pals in Power World look like Pokemon according to many of Pokemon fans. But for the case of this, the emulation, again, it goes back to circumventing technological measures under 1201F, under 17 channels. I mean not channel 17, but law 17 under reverse engineering, as we saw here. If you guys want to read the entire 1201 section of the law under 17, I will be also putting this in the description below if you guys like law stuff. I only added this so that we can get some more context on that law. Not only because we can learn about it, we can apply why it's being played. It's being played for reverse engineering. There's also other sections like other rights, etc., not affected. There's also additional violations, and there's also section A, violations regarding circumvention of technological measures. The whole 9 yards right here. If you want to read this on your own, I will link it in the description below as well, so that even if you're not going to be a lawyer, at least you have an idea of like how the law works according to this and the definitions as well. So that's all for today's gaming news. What do you guys think? Are you guys worried about emulation based on 1201F, or are you worried about emulation based on a fan's perspective? I'm more of a fan's perspective because I play with emulators. I love emulators. They help preserve the games, especially nowadays with modern gaming. What remember the Nintendo Wii shop and the 3DS shop shut down. We don't get those games anymore. So that's why a lot of people are angry. And that makes sense. But remember, Nintendo is Nintendo and they will come after ya if they don't like ya. Okay? That's what we have seen. That's all for today's gaming news. I hope you guys enjoyed that. And we'll see you guys on the next episode of Gaming News. We'll talk about more stuff. Alright, that's it. Enjoy, and as always, we'll see you guys. Live life to the fullest, y'all. And keep on gaming, and let's preserve the gaming, y'all.